Okay, and this video is dealing with who gets the vehicle in the divorce and how is that handled after the divorce is over. And we're hoping that this will help people in Texas that are getting a divorce be empowered with information so that they are more likely to be able to part as friends, having been enlightened as to the different options that there are in a Texas divorce. You should never take a video as legal advice, though it's always important to consult your own lawyer about the individual facts of your case. So, jumping right into it, one of the first scenarios, one of the easiest scenarios is when spouse A is going to be awarded the car and spouse A is already the only title holder on the car and there is no loan owed on the car. In that case, the decree simply has to award the car to wife, listing the model, make, year, and VIN number of the vehicle, and it's as clean as that. Spouse B is not involved as far as having to do any title transfers or paperwork after the divorce is over. Scenario 2 is similar, only in this case, spouse A is on the title and also spouse B is on the title, but there is no financing. So, in that scenario, there would be a divorce decree written awarding the vehicle by VIN number, model, make, and year to spouse A. Spouse A would be able to take a certified copy of that divorce decree to the Texas Department of Motor Vehicles, and using that certified copy showing that there was no outstanding loan on the car, maybe a release of lien would be advisable to have with you. You'd be able to then transfer the title to spouse A in her name alone. Very simple scenario as well. In the third scenario, it gets a little bit more complicated because here you have financing on the vehicle. So the husband is going to be awarded the vehicle, but spouse A and spouse B are both on the title, and there's a loan, and spouse A and spouse B are both on the loan. In that case, again, the divorce decree, the final terms of the divorce, are going to award spouse B the car, but spouse B is going to have to refinance the vehicle. So we remove spouse A from that note, from that outstanding loan, refinance the vehicle successfully, and then spouse B will get a release of lien letter. We'll bring both of those documents to the Texas Department of Motor Vehicles, and we'll eventually be able to remove their spouse A from the title so that spouse B will walk away with his own financing and his own title. And scenario 4 is the least advisable scenario, but also one of the more common that people decide to go with because of needing to settle their divorce, and that's sometimes the only terms that their spouse is willing to settle on. So in this scenario, spouse A is going to take title to the vehicle or is going to be awarded use of the vehicle, but both of them are on the title to the vehicle and both parties are on the outstanding loan. And in this scenario, spouse A, although she's taking the vehicle in the divorce terms, she does not have good credit, or for whatever reason, she's not able to pay off the loan, able to pay off the car, and is not going to be refinancing the car, but still is going to get the car as the parties' agreement in the divorce. In this scenario, spouse B is going to remain there on the outstanding loan, and the divorce decree is going to award the 100% interest in the vehicle to spouse A, but will also order spouse A to make the monthly payments to the financing institution on the date due for the total that is due each month. And it's important that the decree will do that specifically. But in order for her to be able to take ownership of that car effectively with the Department of Motor Vehicles, husband is also going to execute a power of attorney to transfer motor vehicle, and that document does not operate to change the actual title holder, but will operate to allow her to insure the car, get it inspected, and take care of the car as an owner. Now, this scenario, we say it is inadvisable or the least desirable scenario and outcome because spouse A has to make those monthly payments to that loan on time. And if she doesn't, because spouse B is still on the note, spouse B's excellent credit score is at risk by his ex-spouse's acts after the divorce. Again, not ideal because you don't want to have any ties to your spouse that are obligatory after even the most friendly of divorces. It's best to have all those ties cut if possible at all. Now, importantly, because spouse B's credit is at risk there, you could have a repossession clause in the decree that would allow spouse B to keep a key to the car. And if spouse A doesn't pay the car, then spouse B could be allowed to repossess the car from her to protect his own credit. But there is another downside to this scenario, and that is that the liability follows the vehicle, as the Department of Motor Vehicles clarifies on its website, as we link to on our webpage here. And because the liability follows the vehicle and spouse B's name is still on the title itself, spouse B is potentially liable for the accidents of the vehicle of spouse A. Spouse B, for instance, could be found liable for negligently entrusting spouse A with his vehicle. Because of that possibility, and altogether this picture is not what we advise, and it's the last route to take if you're settling the divorce. Better to try to pay off the car with some other asset of the divorce if possible, so that the title can be given free and clear. Now, very importantly, when you do go through the final terms of your divorce, whatever scenario you do have, if the decree doesn't write it properly, then you don't have that scenario, because you only have as much as what is written in your decree of divorce. So really review that carefully as to the vehicles and to all other terms when you're doing a divorce, whether it's friendly, as we advocate for, or whether it's a contested divorce. Thank you, and thanks for stopping by.